Members of the military are at risk of losing their careers, their livelihood, for behavior that is often not even a crime in the civilian system. That's why you need to know the facts. You need to know your options, and you need the help of experts when facing military justice.
Hi, I'm Jim Buchanan, and welcome to another edition of Military Justice. Our guest today is Jonathan Crisp, who is a trial attorney specializing in military law at Crisp and Associates. Welcome, Jonathan. Good to see you.
Thank you much.
Today, we want to talk about domestic violence, specifically Article 128B of UCMJ. What is all that? What does the initial stand for?
Sure. Uniform Code of Military Justice. Okay. The military has a code that codifies basically all the different violations and punitive articles that a service member can violate. And that is the shorthand for the code, the punitive code that the military has. In this particular case, 128 Bravo is a charge involving domestic violence. There was a change 2019 to the NDAA, National Defense Authorization Act, that changed it from, used to be spouse or battery upon a spouse, intimate partner, or immediate family member. They've now just called it domestic violence. And those are the individuals against whom you can be accused of committing a domestic violence offense.
And then what kind of charges are under 128B?
Strictly relating to, well, I shouldn't say strictly, it's relating to anyone with whom you had formerly cohabitated but now maybe have a child together, someone with whom you were intimate. It's a pretty broad definition. Typically, it is usually in a situation where there's a breakup ongoing or the relationship is currently existing. However, it can be used to apply to a former lover or a former romantic partner. And what you often can still see it apply to is you have two individuals who had a child together who may or may not have been married but are separated now and have been separated for a long time. It can apply in those scenarios as well. So it has a pretty broad reach, and it is unique in that capacity.
Is it gender specific?
It is not. So you have seen, and we have seen at Crisp and Associates, a number of charges involving same-sex domestic violence cases arise in the last 2 to 3 years, because obviously the military has repealed Don't Ask, Don't Tell, and now it is it's no longer improper or illegal in the military to actually cohabitate with someone of the same sex and have a romantic relationship.
Well, speaking of that, is it limited to romantic relationships or not?
It is not.
Okay.
You're going to see it comes into, as we talked about a short time ago, it can apply to old relationships that there may still be a stalking or violent relationship ongoing that arises out of the blue. I think the most common scenario is what we said, and that is if you have a child together and there's a dispute there, and it can also obviously be against a child, so it doesn't even have to have, there's no romantic aspect in that certainly, but it can be against a child, it can be against a former partner who's raising that child, and you haven't had a cohabitation relationship for years.
So what's the punishment from lowest to maximum?
Lowest obviously is no punishment at all, but what you're looking at is a statutory maximum period of confinement of 2 years, which is somewhat unique in the sense that it doesn't require an aggravated harm or serious bodily injury. It can be an offensive touching. So in most assaultive contexts where you just have an offensive touching but there's not significant injury, you have a much lower statutory maximum period of confinement. But the problems you're dealing with here is this triggers a Lautenberg Amendment registration issue in terms of your inability to possess firearms. It's obviously a felony level offense for the federal calculation purposes. So it has a significant number of consequences that a typical, offensive touching assault would not otherwise have. So they have, military has made great change to both the Article 120 sex assault offenses and now as well the domestic violence offenses.
So how can Crisp and Associates help?
If you are being investigated or in fact ultimately charged at court-martial, we have seen a huge surge in these cases, and we know how the prosecution is going to start going after these. They're going to employ a psychologist who's going to talk about the wheel of violence, a circle of violence, the wheel of power and control, I guess is the accurate phrase, and how to combat that, how to challenge whether or not that actually exists. And we have our own experts that we can employ to attack the allegation that this is really a domestic violence related issue as opposed to just a generic issue or no issue at all. I mean, we've seen probably 6 to 8 cases in the last 12 months alone in terms of going to court, and have been successful in challenging the underlying basis for that, and that, trying to establish whether harm actually exists or harm actually even occurred. So bodily harm is the key.
So timing is everything. So
Mhm.
when should someone get in contact with you?
The moment CID, NCIS, OSI shows up at your door and wants to talk to you, or that you're being asked about it, they're not there to talk to you because they think you're a nice guy. They're there to talk to you because they think something's going on and they want to incriminate you. So if there's an allegation, and at any point in time is when you want to reach out, the sooner the better.
Domestic violence, a topic that needs to be addressed, which you just did, and thank you for doing that. Always
sir.
great advice. That is all the time that we have today for Military Justice. Thanks, Jonathan, for being here with us today. If you're interested in learning more about today's topic, go to mymilitarylawyers.com. Remember, you need to know the facts, you need to know your options, and you need the help of experts when facing military justice.